I'm pleased to be with all of you today to discuss a bill that I'm proud to sponsor and is priority business. That bill is the Effective Assistance of Counsel in the Digital Era Act. It goes to the heart of the attorney-client privilege. All of you know that's a fundamental underpinning of the United States criminal justice system. To safeguard the privilege, the federal government already cannot access attorney-client communications conducted through in-person meetings, phone calls, and snail mail in Bureau of Prison facilities. Yet those guardrails do not extend to email at federal prisons. My friend, Senator Lummis of Wyoming, has joined me in introducing bipartisan legislation to close this gap. It brings prison regulations into the 21st century. Recognizing that attorney-client privilege extends to email is just common sense. This important legislation has already passed the House of Representatives with more than 400 votes. I'm pushing hard to get this bill through the Senate and signed into black letter law. I hope you'll join me in making this push. Together, I'm certain we can do it.
Hello, I'm Megan Graham. I'm a supervising attorney in Berkeley Law's Samuelson Law, Technology, and Public Policy Clinic. I want to thank President Turner and ABA Day Planning Chair Bill Bay for the chance to speak with you. And I should say, happy 25th anniversary for ABA Day. My students and I have been working for the last 5 years to solve the problem of attorney-client emails being read in the federal prison system. As part of that work, I've had the honor of talking with dozens of experts and attorneys who have to deal with the monitoring of their clients' emails on a regular basis. Email is a major tool for communication and a core part of practice today, but it remains unusable for most people working with incarcerated clients. They are left with only slower or more expensive alternatives while trying to provide legal assistance to clients in jails or prisons, whether that's on criminal cases, appeals, family law matters, civil rights claims, or some other legal issue. For those of you who don't work with incarcerated clients, please take a moment to think about how you would carry on your practice and do your job if you couldn't email your clients. That's the biggest thing I want to highlight for you. Monitoring of attorney-client communications based on someone's carceral status undermines attorneys' ability to do their jobs and means that clients cannot share privileged information with their lawyers in an efficient manner. It makes the work we all do much harder than it needs to be. The Effective Assistance of Counsel in the Digital Era Act helps solve this problem. It recognizes that people need to be able to talk with their lawyers confidentially and that they shouldn't be hamstrung in doing so just because they're in a jail or prison. It recognizes and protects lawyers' ability to communicate with their clients without the government being in the middle. It may seem like a small bill, and maybe it is, but I assure you that the Effective Assistance of Counsel in the Digital Era Act would make a big difference for real people, for your colleagues, maybe for you, and for clients. It's a common sense fix that would measurably change how lawyers work with their incarcerated clients. And I urge you all to support this bill getting passed. It's well past time to protect privilege in these emails. Thank you.
Welcome to ABA Day in Washington, D.C., and congratulations on this being the 25th anniversary. I just want to express my thanks to the ABA for all of your efforts in helping to uplift the principles of liberty and justice for all, equal protection under the law, and ensuring that the civil and constitutional rights of all Americans are vindicated in the most robust way possible. I also want to thank you for your support of the Effective Assistance Act, which has successfully passed the House of Representatives with strong bipartisan majorities and has a pathway into passage in the Senate. This legislation, like all of the initiatives that the ABA backs, is designed to just make sure that we can defend and protect the rights that have been granted to all in this sacred democracy of ours. Thank you, congratulations, God bless you all, and God bless the United States of America.
Hi, everyone. I'm Ken Goldsmith in the ABA Governmental Affairs Office, and I handle criminal justice reform issues for us, including the Effective Assistance of Counsel in the Digital Era Act. Thank you for being a part of ABA Day and supporting this critical issue. The attorney-client privilege should not be so easily denied to those people in the federal prison system, whether they're serving a sentence or being held pretrial, which is to say presumed innocent and very much in need of legal help. You just heard from some of our champions who have been responsible for introducing strong bipartisan bills in both chambers of Congress, and that's evidenced by the overwhelming vote of support in the House. We're grateful to our congressional leaders and their staffs, including Representatives Jeffries and Taylor in the House and Senators Wyden and Lemus, for positioning us for success. But without the help of constituents like you, it is far less likely that these efforts will succeed, and I want to tell you why. Strong bipartisan support in the House is not translated into overwhelming numbers in the Senate, and the Senate leaders are currently deciding which very few criminal justice bills will be brought to the Senate floor this Congress. The Effective Assistance of Counsel in the Digital Era Act is one of the bills reportedly under consideration, but Wyden and Lemus will first need to show broader support among their colleagues in the Senate if it's to be included. You are coming in at the perfect time while those deliberations are happening behind closed doors. By calling or writing your senators to co-sponsor Senate Bill 3524 and support either the House or Senate bill's inclusion in any vehicle destined for the Senate floor, you will be playing as integral a role as anybody in the bill's future. And because anything passed in the Senate may be a different bill number or have slightly different text than what was approved in the House, then without your House members' continued vigilance, the job could be left unfinished. We need their support just a little bit longer. So now it's your turn, and we've made it easy for you. Working through our system, you can read about the issue, see the supporting documents for yourselves, and review the talking points that matter most to you. And then at the click of a button, emails to each member in your congressional delegation will come up in turn, which you can make stronger with even modest changes to the default language so that it's in your voice. If you prefer to call, you can pick that option. The talking points and script are going to be right there for you. And by selecting that option, the congressional switchboard system will actually call you and connect you in turn with each office. So it's go time. While you prepare to reach out to bring this effort in defense of the attorney-client privilege to a successful close, we'd like you to hear from some additional allies who have been with us each step of the way. Again, thank you for your support and for being part of this quarter-century ABA tradition.
Hi, I'm Jason Pye, Director of Rule of Law Initiatives for the Due Process Institute. Due Process Institute is a nonprofit that works to honor, preserve, and restore principles of fairness in the criminal legal system. We work in a bipartisan fashion, focusing on achievable results based on core principles and values that are shared by all Americans. I'm very pleased to join ABA Day in Washington, D.C., celebrating its 25th anniversary, and I'm grateful to the ABA's leadership for the invitation to speak to you. One of the numerous due process concerns we partner with the ABA on is supporting the sanctity of the attorney-client privilege. This session, we are working hand in hand to pass the Effective Assistance of Counsel in the Digital Era Act. We need to create a system to allow those in federal custody the right to confidentially communicate over email with their attorneys. This is an essential part of due process. This would simply extend the same protection from government monitoring that is already given when someone in custody contacts their lawyer through the mail, on the phone, or in person. This is a long overdue reform, and one that would not only ensure fairness, but would also reduce cost and preserve BOP resources. Conditioning a person's email access on their waiver of the attorney-client privilege is coercive and undermines the constitutional Sixth Amendment right to the effective assistance of counsel. Your voice, the voice of the entire legal profession, is absolutely critical in helping Congress understand the importance of the issue. We are grateful for your support for this important bill. Please ask your senators to co-sponsor S3524, support the inclusion of these reforms in any criminal justice vehicle destined for the Senate floor, and for House members to remain vigilant to take action on whatever passes the Senate. Thank you for your work on this critical campaign.
I'm Lisa Wayne. I am the Executive Director of the National Association of Criminal Defense Lawyers. I'm a longtime defense attorney I've been practicing for 36 years. I was a public defender and I practiced in private practice, both in state and federal courts around the country. I'm coming to you today to discuss the importance of HR 546, Effective Assistance of Counsel in the Digital Era Act, bipartisan legislation passed overwhelmingly by the House and pending in the Senate. It would ensure email communication between defense teams and their clients in the Bureau of Prisons custody remain confidential. Attorney-client privilege is one of the oldest privileges for confidential communications. It has been an important part of the U.S. legal system for hundreds of years. This privilege is critical when clients are in custody, and its importance does not diminish when imprisoned clients consult with their attorneys via email. It is a vital protection that allows the accused to participate in their own defense and feel like they have power in the consequences. Attorney-client privilege is the client's right to refuse to disclose and to prevent any other person from disclosing confidential communications between the client and the attorney. Courts have endorsed attorney-client privilege for hundreds of years. In 1888, the U.S. Supreme Court said attorney-client privilege is, and I quote, founded upon the necessity of the aid of persons having knowledge of the law and skilled in its practice. In the court's view, effective legal assistance can only be safely and readily availed of when free from the consequences or the apprehension of disclosure. 100 years later, the Supreme Court reaffirmed privilege when it wrote that attorney-client privilege promotes the public interest in the observance of law and administration of justice by ensuring that attorneys can communicate freely with their clients. Courts were still citing this language in 2019, demonstrating that the attorney-client privilege is a core tenet of a fair criminal justice system. The privilege is rooted in history, and it remains essential today. It has very few narrow exceptions, but broad, sweeping coverage is still necessary for ensuring equity in America's adversarial system. The fact that much attorney-client communication now takes place through email is a reason to extend the privilege to email, not a reason to confine its scope to older forms of communication. Private communications between a lawyer and their team and their clients are sacrosanct. It is the cornerstone of a fair criminal justice system. Calls and visits between an incarcerated person and their defense team are privileged, but emails are currently the only form of communication where clients are coerced into waiving privilege in order to be able to communicate with their defense team. This remains true whether the client is incarcerated, pre-trial, or post-conviction. Unlike other forms of communication, inmates who use the email system at the Bureau of Prisons facilities must consent to government review of their attorney-client communications, the contents of which can be accessed by the prosecutors. The last 2 years of COVID restrictions have made the issues with the lack of protected email communications even more acute. In the early days of the pandemic and for many, many months afterwards, prisons banned visitors to try and contain the spread of COVID. In many prisons and jails, it's still that way. Communications between incarcerated people and their attorney teams became even more critical, especially for those concerned about their health and the conditions of their confinement. It also put pressure on all other means of privileged communications, making it significantly more difficult for incarcerated people to communicate with their attorney teams in any form. This recent experience really shows the need for truly protected email communications between attorney teams and their incarcerated clients. Under the current Bureau of Prisons policy, the contents of all emails sent or received by an inmate, that includes attorney-client email, may be reviewed by prison officials as part of monitoring of inmate electronic message activity and conducting investigations. Email messages and related data may also be shared with other law enforcement entities, whether it's federal, state, local, territorial, tribal, or foreign, if the information is relevant to the recipient's entity's law enforcement responsibilities. The Bureau of Prisons may also share prisoner email data in an appropriate proceeding before a court or an administrative or adjudicative body, when either the Department of Justice or an adjudicator determines that such data is relevant to a proceeding. BOP policy, the Bureau of Prisons policy, does not require subpoenas for these emails. The Bureau of Prisons merely requires a written request. Upon receiving such a request, staff at the Bureau of Prisons, they're authorized to release both transactional data, for example, the date, the time, electronic message address, electronic message recipient and sender, and the length of the message, and copies of the content of electronic messages. This stands in stark contrast, for example, to the BOP's copies of recorded telephone conversations, which the BOP may only disclose when an emergency situation, when criminal activity is discovered, when formally requested with a subpoena, or requested by the FBI for national security or foreign intelligence purposes. In December 2018, the National Association of Criminal Defense Lawyers, represented by the Samuelson Law, Technology, and Public Policy Clinic at Berkeley Law School, submitted a FOIA request to the Department of Justice, seeking all information on how the Bureau of Prisons email system, known as TrueLinks, also CoreLinks, how it functions. Through that process, the National Association of Criminal Defense Lawyers obtained more information about the way the system is administered by the Bureau of Prisons. As of June 20th, 2017, a new feature was added to TrueLinks, CoreLinks, that allows the Bureau of Prisons to filter out specific emails when conducting a search of an inmate's email activity. The filtering feature allows the BOP staff to produce emails for law enforcement while excluding specific email addresses from the requested search, including email accounts that belong to attorneys. The Bureau of Prisons will filter out emails only upon explicit request from requesting law enforcement officials. Thus, this filtering capability's use is dependent upon individual law enforcement officials exercising discretion in their request. BOP states that it is not responsible for verifying that the email addresses provided be filtered out are correct, leaving that responsibility to the requesting law enforcement official. Further, the Bureau of Prisons has indicated that the requesting law enforcement official is also responsible for verifying that all attorney-client privileged emails have been excluded from the production. This filtering system is not a robust structural solution, and there's no auditing system in place to monitor its compliance. Furthermore, the system invites inconsistencies in practice across different districts. The filtering system does not adequately protect attorney-client privilege. The Bureau of Prison and other government agencies can still review the emails between inmates and their lawyers, and may cause more harm if attorneys and inmates are misled to believe that their emails will not be produced to law enforcement authorities. In 2022, email is the most convenient form of communication between defense counsel and their clients. Calls can be difficult to schedule, and out-of-town visits to jails or prisons can be costly and very time-consuming. Email communication can be helpful for clients who have challenges communicating or communicate in languages other than English. It allows neurodiverse people the time they need to process information and the ability to respond in their own time. For all these reasons, NACDL is urging Congress to pass the Effective Assistance of Counsel in the Digital Era Act, bipartisan legislation that passed the House overwhelmingly with a 414-11 vote. The bill, pending in the Senate, designates emails between people in the Bureau of Prison facilities and their legal team as privileged, only allows emails to be accessed with a warrant, mandates a taint team whenever email communications are requested, and includes a strong suppression remedy. The bill was introduced in the Senate in January of this year by co-sponsors Senator Ron Wyden and Senator Cynthia Lummis. And the National Association of Criminal Defense Lawyers is urging Congress to pass this bill and ensure that all attorney-client communications remain privileged communications.
Thanks to all of our speakers on the effective assistance of counsel in the Digital Era Act. And thank you for taking action. If you are still sending your messages, please proceed, take your time. But when you're ready, please join me over in the Legal Services Corporation event on your agenda, or simply follow the link below as we welcome Legal Services Corporation President Ron Flagg to start us off.